most frequently asked questions is, one, does the landlord have to return your security deposit? The landlord has to return the security deposit within 21 days of when your lease ends. There are a few exceptions to this. If you move out in the middle of your lease, if you notify the landlord in writing that you're going to be moving out, the landlord has 21 days from the date that you notify them, unless they haven't found somebody new to move into the apartment. At that point, they can keep the security deposit until someone new moves in, and they have to return it 21 days after that. Generally speaking, a landlord cannot deduct for anything that is considered normal wear and tear. Normal wear and tear is up to the individual judges to determine, but typically speaking, if it's something that would happen to an apartment while people are living there, that isn't something that's been purposely damaged or spilled on or somehow had some abnormal thing happen to it, you should not be charged for it. So a few scratches in the countertop, a few nail holes in the walls are probably considered normal wear and tear. But if you spilled bleach on the carpeting, that may be a different matter. One of the biggest areas of disagreement is over carpet cleaning. The law clearly says that that landlords are not allowed to charge for things that are normal wear and tear. So if every tenant in a building gets charged for carpet cleaning when they move out, that is probably normal wear and tear. Landlords should only be charging tenants for carpet cleaning if it's something that is beyond normal wear and tear, something where there is unusual damage or something happened that is different from the rest of the units. So landlords should not be blanketly charging everybody for carpet cleaning. When deducting from a security deposit, landlords can deduct for a few things. The first one is for any unpaid rent that you might have. The second is for unpaid utilities. And the third is for any damages that may have been done to the apartment, things that are beyond the normal wear and tear that we previously talked about.
Definitely read any non-standard rental provisions in your lease. This is going to be a separate piece of paper where you may have initialed that the landlord is allowed to deduct late fees and other types of charges from your security deposit.
Landlords cannot just deduct for random fees for various items unless you've agreed upon them in advance. One good example of this is late fees. If the landlord is going to charge you late fees, first they must put late fees in your lease, and second of all, they must tell you that they're going to take any unpaid late fees out of your security deposit. So it's important that if they're going to take any fees out of your security deposit, that's written into a non-standard rental provision and you both parties have agreed upon that in advance. Another thing that landlords do that is problematic is that sometimes they just say, if you leave your apartment messy, we will charge you a random dollar amount for each item. So if your stove isn't cleaned, we charge you $50. If your refrigerator isn't cleaned, we charge you $100. They can't do that. They have to charge you for the actual time that they spend doing the repairs, and they have to charge a reasonable amount per hour. So if the landlord is an attorney and they want to charge $200 an hour, the judge probably won't allow that. They'll charge what it would be for someone to clean the apartment, so it may be more like $10 or $20 an hour.
So what do you do if your landlord does not return your security deposit in time, or they send you a list of deductions you disagree with? The first thing to do is write a letter. You can be very polite and very professional when you do this. We do have a sample on our website and in our office that you're welcome to use. Basically, you're just going to say, I got your note and I disagree with it. Here's why. If there are deductions they've listed that you don't think were your fault or you think it was normal wear and tear, give them a line-by-line explanation of why you think that you are being more reasonable here. If they don't return your deposit, you do have the right to file a complaint with the Department of Consumer Protection and sue them in small claims court for up to double the amount they withheld. That is a very persuasive thing to include in a letter to the landlord. If they know that you're willing to go to court for double, plus court costs, plus reasonable attorney's fees, they may think, I don't feel so great about that gray area of normal wear and tear. Maybe I'll back off and just return the deposit. It can be effective in some cases. Some cases it's not, in which case you would go to your local small claims court and file a case for money damages. You'd want to list double the amount you feel you were owed, plus court costs and reasonable attorney's fees. When you go to court, it's important to bring as much documentation as you have. Your check-in sheet, your checkout sheet, any videos, any statements from witnesses, things of that nature.
If a tenant gets a partial check back from the landlord, it's okay to cash that check. You don't have to wait till full settlement of the dispute is done. So if you get $200 back out of a $500 security deposit and you want to dispute the other $300, it's okay to cash that check. The law says that that is not accepting what the landlord's determination is of how much should be taken out of the security deposit. When there's multiple roommates, one complication can arise when the landlord is required to return the check to every single tenant that was on that lease. So if you had 6 roommates, the landlord is required to write the check out to all 7 roommates. And oftentimes banks have difficulties cashing checks unless everybody signs the back of that check. So if you want the check to go to someone in particular, you should make sure that you make a written agreement with the landlord in advance before they write that check. Many tenants wonder if they should be entitled to interest on their security deposit. Unless you lived in Madison between 1985 and 2011, the answer is no. During those years, the interest rate that was required varies, and so I would contact the Tenant Resource Center to find out what interest they owe. But beyond that, landlords are not required to pay interest on your security deposit.